basic overview of the rate litigation and where it's at. The first part of that today will cover the 2010-2012 cases. There are a number of lawsuits between Metropolitan and the Water Authority. Each time Met enacts their rates, because they're doing it the same way each time, it would generate a new lawsuit. There's only one set of cases that have already been tried and gone through the process, and that's the 2010-2012 cases. Next slide, please. So these particular cases were filed in 2010 and 2012, but they cover Met rate years 2011 through 2014. These are the cases that you've read about in the newspapers or elsewhere and heard information about that actually went to trial, went up to the Court of Appeal, and got an ultimate result. In terms of what happened in the cases, in terms of the substance, we lost our state water project issue. We had argued that the state water project costs should not be chargeable to the exchange agreement transportation rate. The Court of Appeal disagreed with us, and that resulted in about ballpark approximate $242 per acre foot difference in rates. Those are rates that we're already paying. These lawsuits were not basically these lawsuits we were paying the money. You have to basically pay the disputed rates while you challenge them. So the rates had all been paid, and these were cases about getting money back. We did win all the other key claims, a number of other significant issues that were won by the Water Authority, and we want to cover those today quickly. And basically those break down into two categories. There are benefits that were won in the case itself that apply directly to the case, and as well as those that are affecting other things outside the case itself. We also want to talk about what remains to be litigated in those cases, because as you'll see, the cases have to go back to the trial court. At a later date, we'll go through the stayed cases that follow the 2010-2012 litigation. Next slide, please. All right, so as I said, there's two kinds of benefits achieved by the Water Authority in this litigation. The first one are in-case benefits. The first one of these I want to cover is the water stewardship rate being charged to the exchange agreement. Metropolitan and the Water Authority have a contract called the exchange agreement. There were rates agreed to be charged under that. Included in those rates, Met was charging us their water stewardship rate, which is a charge that they apply basically for conservation programs and other similar funding of different programs of theirs. We argued that they were not allowed to charge that, and it was a breach of contract to charge it. They argued it was allowed to be charged and was not a breach of contract. The courts agreed that Metropolitan had breached the contract with the Water Authority by charging those rates, and I can tell you, for example, at oral argument, Justice Pollack, when Metropolitan started to argue this issue, literally read quotes from Metropolitan's record stating that these were supply costs, not transportation costs. And he read extensively from the record and quoted it all to Met's counsel. So we won that issue. That was a significant victory. The value of that was approximately $44.4 million. That includes principal and interest to date. Next slide. If you took that $44 million, $44.4 million and broke it out by agency here based on water sales, this would be the numbers that come out. These are, there's approximate numbers, there's some rounding that occurs, and therefore if you added all these numbers up, as I did, and see it comes to 44.3 instead of 44.4, it's because of the rounding issue. But this is how they would break out by agency if you were to list them that way. This doesn't count the litigation costs, of course, that were expended, and the numbers are rounded. Next slide, please. So in addition to that issue, we also, in the case, won a victory on preferential rights being recalculated. Under the Metropolitan Act, which is passed by the state legislature, there is a priority scheme for water, for Met's water. And under that scheme, under the code section, each member agency of Metropolitan is entitled to preferential rights of Met's water. As in all water priority systems, that tends to have the most focus when there's a shortage, but it always exists. And Metropolitan was contending that the water we paid under the exchange agreement, what's that? The money we paid. Yeah, the money we paid, pardon me. The money we paid under the exchange agreement did not count for preferential rights. We said it did count for preferential rights. And Met's argument was that we were purchasing Met water. And we said, no, we're not purchasing Met water. We're purchasing conserved water from the Imperial Valley. We're just using the Met system to transport that water. The court agreed with us, said that these preferential rights had been miscalculated by Metropolitan, and the corrected calculation comes out to about 100,000 acre-feet per year increase for the Water Authority in years where Met has about 1.75 million acre-feet available of supply. So it's a significant amount of water. It's a significant priority to have in potential times of shortage for this region. It was one that Met was not giving to us voluntarily. Met had to be compelled by the courts to give it to us, and in fact they have done so, and their recalculations now show the changed calculation. Next slide, please. In addition to that, there was something called the Rate Structure Integrity Clause. What Metropolitan did was they inserted basically a poison pill clause into their conservation agreements with member agencies, whereby if the member agency dared to challenge Met rates, either in the courts or even go to the legislature to try to get some changes there, they would lose the value of their conservation contracts, and the conservation contracts would be ended. We said that was unlawful. Met said no, it's lawful. And in fact, there's documents that show that Met did it purposefully to chill the Water Authority doing anything. And we went to court, and the courts found that Metropolitan had indeed violated the state constitution and in imposing this kind of clause on member agencies. So the result is of that litigation that Met can't force member agencies, such as the Water Authority or any others, to forego their rights to challenge rates or Met policies, et cetera, in order to get program benefits, i.e. the local resource program and conservation program funding. The value of that, of course, is that now the Water Authority and its member agencies, we can apply for conservation and local resource program benefits from Met, and in fact, we're doing so. There's, as you see on the bottom bullet there, 3 LRP applications have already been submitted by the Water Authority and member agencies. More are in process as more agencies submit paperwork to the Water Authority to submit to Metropolitan. And Metropolitan already sent correspondence to the Water Authority acknowledging that the conservation credits program funding had been restored, and that's about $800,000 annually. Again, these are benefits that Met did not voluntarily give. These are all benefits that were acquired only because this agency decided to go to court and challenge Met's actions, and the courts agreed. Next slide. Now, in addition to things that actually were determined in the 2010-2012 cases that affect those cases directly, there were also results that affect other things outside that case. The first one is that issue of the water stewardship rate not applying to exchange agreement water. That has value for all the cases that are stayed behind it, which means years behind, of Met rate charges that are represented in those cases. And if you look here for 2015 to 2018, that has a value of about $42 million principal and interest. For years 2019 to 20, that's about a $34 million avoided cost. That comes out to about $37 an acre foot to Water Authority rates per year in 2019 dollars. As you heard earlier from Director Lewinger, Metropolitan wrote correspondence to the Water Authority basically saying we're proposing to our board to not charge these rates up until the 2020 cycle, and so therefore we don't anticipate these will be charged to the Water Authority. Met's board has to make a decision. The next item is additionally the water stewardship rate is potentially not chargeable in the future. 2021 through the end of the exchange agreement, which is 2047. That has a significant value of up to about $1 billion in reduced costs for the member agencies here, and that's about $18.5 million per year in 2021. The values change over time because the volumes of water change, and also Met rates, there's projections about Met rate changes that occur over the years, and that results in about an offset of $42 an acre foot for the Water Authority rate as of 2021. So these are all items that potentially give significant benefit to the Water Authority that resulted from the 2010-2012 rate litigation. Next slide. There was also an argument about what's called the Wheeling Law. It's Water Code Sections 1810 et sec, whether that applies to the exchange agreement. The court, Metropolitan contended it didn't. The court disagreed and applied the Wheeling Law to the exchange agreement. The Court of Appeal did. We're going to discuss the value of that in a minute on offsetting benefits. The court also applied Prop 26. Met said Prop 26 doesn't apply to us. The Court of Appeal applied Prop 26 to the rates. That has value for application for the cases that are stayed sitting on the runway behind the 2010-2012 cases. And additionally, these cases are called validation cases, and there's law that allows public agencies to validate, or people who challenge them to invalidate, actions of public agencies of certain actions. And those validation cases can have significant results that bind the world beyond just the case itself. So because these are validation cases, there's value in those validation judgments, and potentially that'll streamline the later cases and potentially also limit Met circling back on decided issues. Next slide. So what's the current status of these cases? They've been remanded back to the trial court. The Court of Appeal issues what's called a remitter, sends the matter back to the trial court to decide the remaining issues. We have not yet, that was done in October. We don't yet have a schedule from the trial court as to what's going to happen exactly, but at some point the trial court has to take the matter up again. What issues are we going to be looking at there in terms of significant issues? Things that still have to be decided. Let's take a look at those. Next slide. The first one is offsetting benefits. The water code sections that I referred to earlier that Met contended did not apply and the Court of Appeals said did, have requirements about setting compensation for the agency that allows access to its transportation infrastructure, as Met does here. Met, the code sections list a whole bunch of costs that Met can charge, and there were arguments about what costs they could charge, such as the State Water Project. But the code also requires that there be reasonable credit for any offsetting benefits for the use of the conveyance system. Because the court had invalidated the entirety of the rates on other grounds, this issue was although it was raised at the trial court did not decide it, and it also wasn't then decided when it went up to the Court of Appeals. So that issue has not yet, no court has yet ruled on that particular issue. And if you look at Met's record in the case, there's substantial evidence for significant value if we win that issue. Next slide. Now, in terms of the RSI clause, because the RSI clause existed, we lost certain agreements. I mean, there were agreements that were canceled and stopped. That issue has not yet been decided at the trial court. The trial court had ruled as a procedural basis that we didn't have standing to raise the constitutional issue. We disagreed with that and took it to the Court of Appeal, and the Court of Appeal agreed with us and said we did have standing. And so we will now, make those arguments now back at the trial court, because the trial court will be forced to let us make the arguments pursuant to the Court of Appeal ruling. Additionally, on attorney's fees, there had been an issue at the trial court level about we won a portion of attorney's fees and another portion was denied. The Court of Appeal reversed the trial court on its position that we couldn't make one argument, and so basically it's sending the whole matter back to the trial court to look at again. We have about $11.5 million in fees that are at issue that the trial court will have to make a decision on. Next slide. So in conclusion, these cases that were already litigated provided significant benefit to the Water Authority. We won a host of issues with significant monetary and water value for the Water Authority and its member agencies, even though we did lose the State Water Project issue. There are a number of those issues the trial court still has to decide. I know a lot of folks, when the Court of Appeal ruled, they sort of think, oh, it's all over now. That's not accurate. As noted, there's a number of issues that still have to be decided by the trial court. And next month, we'll be going over these currently stayed cases, so you get a sense of what's in those cases and sort of what the process is for that.